Hi, I'm back. It's Emily, founder of Apex Law School Prep and Support. I've gotten some requests to run through the rest of February 2023 California bar exam. So I thought today we could go over question 2. So let's jump in the calls of the question. Number 1, what constitutional challenges can the Attorney General make to the Act, and are they likely to succeed? Discuss. Constitutional challenges, we're in common law land. And number 2, does NASD have standing to intervene? Discuss. So standing is a justiciability issue for common law, and then intervene, that's intervention. That's a civ pro thing. It's about how someone joins a lawsuit. We'll see how detailed we need to go in our analysis of that, but that's what jumps out to me. Let's get started with the hypo. In response to a significant rise in diabetes among school-age children, and based upon links between diabetes, exercise, and diet, Congress has passed and the president has signed the Childhood Physical Education Act, the Act. Okay, so what jumps out to me there that I know what to do with so far is Congress has passed this law. That tells me that a federal law is being challenged. So I'm going to mentally pull up my checklist of issues that I run through when it's a federal law at issue. The first of which is it passed pursuant to an enumerated power? So states have general police power. They can legislate broadly for health, safety, welfare of their citizens. Congress, federal government, does not. They can only act pursuant to an enumerated power, a power that's listed in the Constitution. So that's things like commerce power, taxing, spending, war, necessary and proper, if they're piggybacking it onto something else, things like that. So I know that I'm going to have to find an enumerated power that this law was passed under in order for it to be valid, among other things. And then the president has signed it. So that brings up for me, how do you validly pass a federal law? Bicameralism and presentment. So bicameralism, both houses of Congress need to vote on this law, and then presentment is presented to the president to sign or veto. Here the president has signed it. So quickly IRAC that because it's clearly satisfied. Just say, hey, grader, I know what to do with those facts. Okay, the act administered by the Federal Department of Education. So it's federal agency, it seems like delegation stuff. I don't know if we're gonna have to get into that, but so that makes me think of, provides significant additional funds to states for public schools with daily physical education classes for students. So additional funds, that makes me think that the enumerated power that I want to focus on here is going to be the spending power. These funds are to be used for the hiring of additional physical education teachers and purchase of physical education equipment. Okay, well, I know that for the spending power, Congress has the power to spend for the common defense, which is not an issue here, at least so far, and for the general welfare and PE teachers, physical education equipment that's connected with this diabetes and exercise link makes me think that this would qualify as spending for the general welfare. Okay, next paragraph. Testimony before Congress revealed that on average, public schools spend only 25% of their school lunch budgets on fresh fruits and vegetables. Okay, the act requires that states accepting the funds must enact legislation setting as a minimum that 50% of public school lunch food budgets can be allocated to the purchase of fresh fruits and vegetables. Okay, so two things jump out at me there when I see this must enact legislation. So first of all, conditional spending. So they are attaching, right, to this funding, this thing that states must do, right? They have to enact legislation. So there's strings attached to this funding. So now I know I'm going to IRAC my spending power for my enumerated power, and then I'm going to IRAC conditional spending because of this condition. And then because it's saying that states must enact legislation, that makes me think of 10th Amendment. Anytime I see federal government telling the states what they must do, I'm thinking anti-commandeering 10th Amendment. Okay, next paragraph. Testimony has also revealed that rates of childhood diabetes tend to be highest in minority and low-income communities. The Act has significant additional subsidies for public schools where the majority of the student population is non-Caucasian. Okay, so what I see here is that this Act is classifying based on a character trait. They are giving more funding to majority non-Caucasian schools and less funding to the other schools. So they're classifying based on race there on its face. So I know I'm going to be running through equal protection. They also mentioned low income communities and try to figure out what to do with that because at least on its face, this law is only classifying based on race. Okay, we'll get into that more as we apply. Next paragraph, before the act has gone into effect. State X, through its Attorney General, has brought suit in federal court seeking a declaratory judgment that the act is unconstitutional. The before the act has gone into effect part, that tells me that I want to IRAC ripeness. So ripeness is about whether the case is brought too soon. Is it ripe? Is it ready? If you think about it like a piece of fruit, is it ready for the court to eat? Or should the court wait and let it get a little riper? You do some more fact gathering and wait to hear the challenge to this law. So I'm going to be IRACing ripeness. And then the National Association of School Dietitians, NASD, is seeking to intervene, which we know from question 2, in the Attorney General's lawsuit. So what I see from that, and I know they've asked me specifically about standing for NISD, I see that this is a National Association of Dietitians. It looks like a membership organization. So when I think about standing, I'm thinking about associational or organizational standing. According to its charter, it seeks to promote healthy diets for school-age children, especially through school lunch programs, and the Attorney General opposes their intervention. Okay, so according to its charter, its purpose, right, is to promote these healthy lunches through school lunch programs. When I think about organizational associational standing, I know that the requirements for that are number 1, there has to be standing for the individual members. So injury, causation, redressability for the individual members. Element 2 is that that suit has to be germane to the organization's purpose, so meaning related to their purpose. And this fact about what its charter says it does, promoting these healthy lunches, that tells me that's its purpose, and this lawsuit about a law that would promote healthy lunches seems very germane to related to that purpose. So I'm going to say that's satisfied. And then I know the third requirement for that organizational standing is that the individual participation of the members can't be required. That comes up when you have members that are claiming different amounts of damages. So we need them to each participate to show their damages. That's not an issue here because this is a declaratory relief action about whether the law is constitutional. So that element's going to be satisfied too. And then I see that they didn't actually give me any facts to specify whether NASD is suing on its own behalf, saying that it as an entity has been injured, or rather if they're suing on behalf of the members. So in addition to organizational standing, I'm also going to want to IRAC direct standing for NASD itself. Okay. That's all the stuff that jumps out at me just reading through the facts. So now let's go through and try to briefly answer the specific questions and see how these IRACs would come out. So question 1 was, what constitutional challenges can the AG make and are they likely to succeed? So there's a lawsuit here, right? They brought suit in federal court and they're challenging. So anytime I see that there's a lawsuit, I'm going to want to start with my justiciability stuff. So I remember justiciability by stop running my plaintiff around: standing, ripeness, mootness, political question, and abstention. So I'm always, when there's a lawsuit, always going to IRAC standing. And then the other ones I will only do if they're plausibly triggered by the facts. So standing is injury, causation, and redressability. So we're going to have to show here, if state X, through its attorney general, wants to bring this challenge, that state X has an injury. That means something that is concrete and particularized to state X, different than everybody else, and that it is actual or imminent, meaning they're already currently suffering the injury, or it's imminent, it's going to happen at some point in the future. Here, because the act hasn't gone into effect yet, it's going to be an imminent injury. They're going to be claiming, yes, once this act goes into effect, we are going to be injured. So we have to see if it's concrete and particularized. What I would say here is their injury is going to be that if they take this funding, they're going to be forced to enact this legislation that changes their food budget around. You could make some sort of argument that, well, if they just don't take the funding, then they don't suffer the injury. I think that's problematic because if we accept that argument, then no state that challenges this could ever get reviewed. And so I think the better argument is, yes, there is an injury here. The injury is, look, if we want this funding, we're going to be forced to enact this law. And if we don't want to enact that law, we're unable to take the funding. So I would say that's the injury. It's imminent because it's going to happen once the law is enacted. And then causation, is that injury caused by this law that they're challenging? Yeah, because if this law was structured differently, didn't have that condition, then they wouldn't be injured by it. And redressability, will their injury be redressed if they prevail? Yeah, if this law is struck down, then that condition will not stand. They won't be forced to enact that legislation, blah, blah, blah. So I think you can say state X has standing. And then the next place I go is ripeness, and that was triggered by that before the act has gone into effect fact. So ripeness is, again, about whether that case is ripe, whether it's ready for the court to eat. And it requires two things. It requires that the case be fit for review. Fitness, meaning that the court would not benefit from additional fact gathering. And here, I don't think that's an issue. I don't think we need to wait and see how this law is going to be enforced and what factually it's going to look like, because this is a purely legal challenge saying it's unconstitutional. We can see clearly what the condition is. We already know what those challenges are. So I think fitness is satisfied. The second prong for ripeness is substantial hardship. We need to show that state X will be substantially harmed. It will face substantial hardship if they're forced to wait to get review of this law. And I think you can make the argument here that, yeah, they'll be harmed because if they can't challenge the law now, and instead they have to wait until the law goes into effect, let's say the law goes into effect and they choose to accept this funding, they either are going to accept the funding and they're going to suffer the hardship of having to then pass this new law that changes their whole food budget around, blah, blah, blah. Or they're going to accept the funding and choose not to do the law. And then Congress is going to try to get the money back because they haven't complied with the condition. And maybe they've already, hired the teachers and purchased the physical education equipment. And then they have to, deal with what to do with that when they get the money taken away. So, in their interest, they're just going to want to say, like, court, please just tell us now before we go to all that trouble. Tell us now whether this law is constitutional or not. So I think ripeness, this is ripe. And then I wouldn't do any other justiciability stuff. I don't see any of the other things triggered by this. So then I would just move on. And the next place I would go is state action because it's a constitutional challenge. So we need a state actor, really obvious to satisfy here. We have Congress and, the Federal Department of Education, they're the state actors that are passing and enacting this law. So state action is done. Then I'm going to get into the meat substantively of whether this federal law is valid. And so the first thing I'm going to do is start with that enumerated power. The place that I'm going to go is the spending power because it's spending, they're giving funds. And so as we already talked about, you can spend for common defense or general welfare. This is spending to lower childhood diabetes. So that's health, that's general welfare. So that's fine. And then the next place I'm going to go is conditional spending. So Congress is allowed to condition their funds if certain requirements are met. I remember that with the acronym GERN. The first thing is general welfare, right? The spending has to be for the general welfare. We've established that. The second one, unambiguous. The condition has to be unambiguously stated so states know what they're getting into, right? They have to know that if they choose to take this funding, here's the condition they're going to have to comply with so that they actually are making a knowing choice. I think that that's satisfied here. They're a little vague. They just say the act requires that states states accepting the funds must enact legislation. I think that what that means is that it explicitly says in the law that if states want to accept this funding, they're going to have to enact this legislation. So I think that's easily satisfied. The next requirement is that the condition has to be rationally related to the purpose of the funding. So here, the purpose of the funding is to combat diabetes, right, is what it seems like, right? Hire PE teachers and get more physical education equipment because we have this link between diabetes and exercise. And I think that the condition is, going to satisfy this, rationally related to that purpose because the condition is about these school lunches. And we know that that link in that first sentence they told us is between diabetes, exercise, and diet. So I think the purpose is lower diabetes. Part of the way they're doing that is giving money for more exercise. And then now they're saying the condition is about the diet piece. So I think you can say that that's satisfied. And then that next requirement is that this condition cannot be coercive. So it has to leave states a real choice. We don't know here how much funding this is. It's significant additional funds for public school, blah, blah, blah. We don't know what significant means. If they had said instead that it provides, funding that is the equivalent of more than 10% of the average state's annual budget every year, right? If they said something like that, I'd say, wow, that's a lot of money. I don't really think that a state could realistically say no because they really need that money. So basically at that point, they're being forced to say yes to this condition. I don't think that's the case here. I'd sort of flag that and say, well, it's a little unclear what significant means. But it doesn't seem to me like significant additional funds is going to be such a large amount of money that states really have no choice, right? Like as the Supreme Court has said, they have a gun to the head where they just have to do it. I don't think that's what we're dealing with here. So I'm going to say probably not coercive. Okay, then the next requirement, our last requirement for conditional spending, is that that condition can't violate any other parts of the Constitution. So that would be a problem if this condition said something like, states get this money, but you can only spend it on, groups that, promote this speech message and not that one, right? Like some content-based restriction, First Amendment violation, or you can only spend it on these groups and not those groups, right? Some equal protection thing. Here, the condition is just like spend more money on fruit. So I don't see any problem with that. The only potential constitutional violation I see is right a 10th Amendment issue, which we've already sort of just talked about when we said not coercive. But for that, I would just maybe say, oh, this might violate the 10th Amendment. See below, and then I'm just going to do another IRAC on the 10th Amendment. 10th Amendment says you cannot commandeer, right? The federal government cannot commandeer the states. It cannot force the states to do its dirty work, right? And in the case of Congress, it can't be like, oh, we don't have enumerated power to do this thing, so states, you have to do the thing for us. They can't do that. What they can do is do the carrot, right? That incentive of conditional spending if they're really giving the states a choice. And, as we just talked about, the significant additional funds, I think it's a choice. It doesn't seem like it's such a big amount of money that states are really just forced to do it. It seems really more like an enticement, like a carrot, rather than coercion. So I'm going to say, it's not violating this anti-commandeering. It looks like it's not a 10th Amendment violation. So I think it's going to be valid conditional spending and no 10th Amendment problem. The next place I'm going to go is that next paragraph triggered that equal protection issue for me, right? The minority low income and then the more money for non-Caucasian. That triggers equal protection. So if you want to get fancy with it, you can point out that this is a federal law, and technically speaking, equal protection from the 14th Amendment applies to states. But the Fifth Amendment due process clause has this equal protection component. So really, they're going to be suing for Fifth Amendment violation. Take it or leave it. You can throw that in if you know it. Then I would just get into the meat of equal protection. And equal protection is about classifying based on character traits. So the first place you want to start is by identifying what character trait is being classified. So the classification can be either a facial classification, where the law says on its face, we're treating people differently based on this classification, or it can be facially neutral, where it looks on its face like it applies to everybody, but there's actually this discriminatory intent. So Congress intended the law to classify based on a certain trait, and discriminatory impact, right? The impact of the law is to actually be treating these people differently. So here we have this facial classification of, giving more money to schools where the majority of the student population is non-Caucasian. So the character trait, that this facial classification, is race. The next step you're going to do after you identify the trait is you're going to rank it. So we have in these traits 3 levels of classes where we might rank them. We have suspect classes, quasi-suspect classes, and non-suspect classes. And depending on where it ranks, it's going to get a different level of protection. So race, so this non-Caucasian is a classification based on race. Race is a suspect class. Suspect classes get strict scrutiny, meaning if there's a classification based on one of these suspect classes, it is only going to be constitutional if it is necessary to achieve a compelling government interest. For quasi-suspect classes, it's intermediate scrutiny, right, important to achieve substantial government interest. And then if it is a non-suspect class, it's rational basis, very low bar. It's going to be fine as long as it is rationally related to legitimate state interest. So this one, the facial classification is race, strict scrutiny. So this classification, this treating the non-Caucasian schools differently, is only going to be constitutional if it is necessary to achieve a compelling government interest. So here, the compelling interest is going to be lowering childhood diabetes, right? Health is always going to satisfy compelling interest. I think the bigger question mark here is whether this is necessary to achieve that interest. It seems like they're using race here as sort of a shorthand for where diabetes would be most prevalent, because they say in that first sentence of that paragraph that testimony shows rates of childhood diabetes tend to be highest in minority and low income communities. That tend to language, that sort of gives me the opportunity to say, well, it's a little unclear whether it's necessary to be classifying based on race in order to achieve this compelling purpose of lowering diabetes. Why can't you just give more money to schools in communities that actually have higher rates of diabetes instead of using race like as a proxy? I don't know how you really would come out on that necessarily, but I would flag the issue quickly, if I saw it, and just sort of flag that for the grader and say, oh, there's kind of something going on here. That's what I would do with that. And then we have that low income fact. how do we use that? Because this law on its face really only classifies based on Caucasian. I mean, you want to try to use the fact, you come up with some argument that, like, insofar as they're using, the non-Caucasian as like a shorthand proxy for also meaning low income, then you say, okay, well, if they're classifying based on income, that's a non-suspect class. That would get you rational basis review. That's fine. It would pass that. Um, the other thing that you could potentially do with that is, they've given you these two, areas where childhood diabetes is highest, minority communities and low income communities. And in this act on its face, Congress is only tackling the minority communities. You could throw in some sentence that says something like, Congress is allowed to tackle a problem piecemeal. They don't have to try to solve the entire problem in one law. They can do it incrementally. That's fine. That doesn't save us from our equal protection problems, but is another way to try to use that fact. But that's how I would get through the equal protection stuff. And then, that's really all I see in terms of challenges to that first, the first question about the challenges. There's probably some other stuff you could do there, but that's all that jumps out to me. So then we move on to our second question, which is, does NASD have standing to intervene? So couple things there. We're going to obviously tackle standing. Intervention. If you have some time to explain to the grader what intervention is, maybe you're going to really save your application, your big IRAC about intervention, to write till the end, in case you run out of time, because there's a lot of other stuff to talk about. But it'd be nice to just sort of show the grader you understand what intervention is. So intervention is this absentee, this person who's not in the lawsuit, like knocking on the courthouse door, like, hey, court, let me in. I want to be in the suit. And there's two kinds, right? There's as of right, which means the court has to let you in. And then there's permissive, which means the court has discretion to let you in. So intervention as of right, mandatory, court has to let you in, is allowed in two situations. One, if there's a statute that says, oh, people who fall within this category have the automatic right to intervene. We don't have any facts about a statute here, so that's not applicable. The other situation where you get intervention as of right is if the person who's trying to join the suit, that absentee, has some interest that relates to the subject matter of the suit, and not letting her in is somehow going to impair her ability to protect herself. And that only applies if her interests are not already adequately represented. So here, I think NASD has an interest, related to the subject matter of the suit, because their whole shtick is that they promote healthy diets through school lunch programs, and this law is about doing that, right? School lunch programs. Is their interest really going to be impaired if they don't get to join this suit? I think, on the one hand, they're bound by the outcome, right? If the law gets struck down, it's struck down, and that harms, their interest of wanting to promote healthy diets through school lunch programs. I think on the other hand, are their interests already adequately represented? Arguably, defendant here, right? So, the Federal Department of Education, Congress, they're arguably already going to be representing this interest of saying it's constitutional. So I think, question mark on whether that's really an issue. I wouldn't worry too much about it. I just kind of get in and out of that and then move to permissive. So permissive intervention is allowed when there's a statute that gives that permissive conditional right to intervene. Again, no statute here, so not an issue. Or you also have permissive intervention when that absentee shares a common question of law or fact with the suit. And here, I think that's easily satisfied. The common question that they all share is like, is this law constitutional, because promoting school lunch programs, and is it allowed to be done in this way? So I think you could get that permissive intervention, and then I would just move away from that because it's not really what they're asking about anyway. So what I want to make sure that I have time to talk about is standing, right? So maybe I did the intervention if I had time, maybe I saved it to the end, but I want to make sure I definitely get to standing because that's what they've asked about. And we already talked about this is an association of dietitians. So ideally, I'm going to want to IRAC both associational standing and direct standing, because they didn't tell me if NASD is suing on behalf of itself, asserting its own injury as an entity, or if it's suing on behalf of its members, asserting their injuries for them, right? For all the dietitians. We just don't know. So I'm going to want to IRAC both. Now, some challenges here, right? Potentially like really tricky, right? So first off, standing of an intervener. This may be something you've never thought about before. Something I hadn't really thought much about before either, before looking at this fact pattern. technically, there's a question mark on if you're trying to intervene in a suit, but you're not asserting any claims or seeking any remedies or trying to do any discovery that's different than the parties that are already in the suit. It's kind of a question mark of whether you need to prove your own standing anyway. Um, I wouldn't expect to know that going into this essay, so I would just, if you know that, say that, and either way, because we don't know really what exactly they're going to do if they get into this lawsuit, I would still go through all my standing requirements. That's the first potential I see from this, right? Standing of an intervener. Then I want to think about how is NASD going to intervene, right? Are they intervening as a plaintiff or as a defendant? And they don't tell you here. But we know that NASD wants healthier school lunches, right? That's what this law does. And we know the Attorney General opposes their intervention. So those things together make me think that NASD is going to want to intervene as a defendant because they want to argue that the law is constitutional. They want to uphold it. That's another standing for a defendant. So that may be something you never learned about, never thought about. Technically, it's required. It's just not usually at issue because usually when you're being sued, your injury is very clear, right? So, you may be looking at this and freaking out a little bit of we're standing for a defendant intervener, what is going on? Just remember that your overall purpose here is to show the grader that you understand the concept of standing, right? You understand that the whole point is that we only want people to join this lawsuit if they have some personal stake in the outcome. So, if you know technicalities, great. If not, you just want to try to convey that you understand that concept. So I'm going to do that by running through, right, my associational standing and then my just plain standing. So if I'm going to do the plain standing first, then we need to show injury, causation, redressability for NASD. So NASD has to show that they have some concrete and particularized actual or imminent injury if they're not allowed to join in this lawsuit. And so basically the argument is if they're not allowed to intervene, they can't promote their arguments saying that the act is constitutional. So if the act gets struck down, are they going to be injured? And I think on the one hand, right, yeah, their injury is they like healthy school lunches. This is why they exist. And so this kind of goes against their purpose. On the other hand, I think the counter argument there is do they really have an injury that is concrete and particularized? Is it really some injury that's different than just some generalized grievance that everybody else who, also subscribes to the idea of we like healthy lunches for kids, holds that idea? Is their injury actually really different? And I think that's problematic. I don't see any facts that show that they're actually going to suffer in some different way, right? They're still allowed to continue lobbying and promoting their school lunch agenda if they want to, right? Getting this law struck down isn't going to stop them from doing that. So I would probably come out and say that if they're just bringing a suit on behalf of their own injury, they're not going to have an injury. If you're not sure, or you come out and say they do have an injury, then you cover your bases. You're going to say, however, in the event that they do have an injury, or if you found they do, you're going to go on to causation or addressability. I think their injury here, if you're going to argue that their injury is caused by getting this law struck down, then there is causation. If they're not allowed to intervene, that's going to cause them to not be able to make these arguments. And then redressability, if they are allowed to intervene, they're going to be able to make their arguments as constitutional, more likely that the law gets upheld. I think that's satisfied. And then I would go on, if I saw it, to organizational or associational standing. And that's where we have to show standing on behalf of the individual members, and then germane to the organization's purpose, and individual participation of the members not required. So standing of the individual members, injury, causation, redressability for them. The injury here would then be to the school dietitians. I think that that's a stronger argument to make. Maybe it's a little bit of a stretch. I don't know exactly what school dietitians do, but if it's something along the lines of, the dietitians work at the schools every day, and if this law is struck down, the school lunches are going to be unhealthier. And if they're unhealthier, the school dietitians have to treat more sick kids with diabetes. I think that's their injury. And then causation and redressability, yeah, right. That injury is caused by the fact that they can't intervene to argue that the law is constitutional. It'll be redressed if they can intervene and try to argue that the law is constitutional, more likely to be upheld. Then more likely to have school lunches that are healthy and less children with diabetes. And so I think you can make that argument I think it's a stronger argument to say that there is standing for NASD to assert on behalf of its individual members. And then we already talked about germane to their purpose because it's about these school lunches, so it's related to their purpose. And then individual participation is not required because they're just seeking declaratory judgment. Nobody here is seeking, individual damages or anything like that. Um, can you make some sort of argument because this fact pattern was vague about what NASD is doing? Could you potentially make some sort of argument that they want to intervene as a plaintiff instead? I don't think it's that likely because the attorney general is opposing their intervention, and like, why wouldn't they want this law to be upheld? I guess, like, theoretically, if they don't think the law goes far enough, maybe they're going to try to get it struck down. If you have extra time and you want to make that argument, like, sure, go ahead. You'd be running into the same elements for standing, but just making an argument in the alternative, the opposite of their injury. Like, their injury is if the law is upheld, they'll be injured in some way if you have extra time. There's probably some other stuff, but that's what jumps out at me from this essay. So hopefully that was helpful.